All right, association status. So going back over here, association means control, as we said. If I control a company, then it has implications on, in this case, whether it's a CCPC, if I'm a foreign party, and it also has issues on my limits. So what happened here, it's the case of Mimetex Pharmaceuticals, is the company had 3 directors. One US director in California owned 50%, and 2 Canadian directors, each of them 25%. So on the basis of it, because as we said, a CCPC is a negative definition, it's not 50-50 still not control. It looks like it's a CCPC, or the client thought they were a CCPC. So they file their SR&ED return. The problem here is somehow, during the SR&ED site review, it became privy to either the financial or the technical review, we're not sure who, that during the year, the US director had undertaken certain transactions, like firing the head of R&D and replacing with someone else, and a couple other transactions that they mentioned, without asking the concurrence of another, not, hey, I suggest we fire the head of R&D and replace him, do one of the 2 of you concur? He just did it. And unfortunately, the CIA and the Tax Court of Canada, they said, even though you don't have voting control, that was clear evidence of factual control. So this is not a Canadian-controlled private corporation. It's a foreign-controlled corporation. You lose your $230,000 in cash refunds. Again, very serious. You want to make sure that that kind of information does not get presented to the CRA. And again, if you've got scientists, they're not going to understand the implications of something like that. Right? Very insidious. The lawyers who set this up probably thought they did a great job, bulletproof, but pow, de facto control can sneak up wherever. Another great case on de facto control, probably one of the earliest. The concept of de facto control in the legislation came out late 80s, around 87, 88. So before that, there was no de facto control. Then, from the 90s on, we now have to consider de facto control every time. One of the first cases, this is like around 88, 89, so it was right after the rules came out. What we had here was a very interesting case of a company here called Hospital for Sick Children in Toronto Research. Okay? And it was spun off of the Hospital for Sick Children in Toronto as a non-for-profit originally. And it ended up developing some drugs and devices that made a lot of money, so they changed their charter and became a for-profit company that started paying tax, which then made them eligible for SR&ED credits on their expenses. The government tried to come back and say, well, you're an excluded corporation because you're controlled by the hospital, okay? Which is kind of like government. And they came back and argued, no, we're not controlled by the hospital at all. Their charter said that none of the profits could be used for the personal gain of the directors, and that if they ever wound up the company, all proceeds or any money left had to go back. I mean, they could pay wages and stuff, but they couldn't, the profits basically had to stay in the company. It didn't go to any shareholders. There were no shareholders. So it was a very interesting case where you had a non-for-profit that has no share capital, that became a profit-oriented company that would normally have share capital, but they just never issued any share capital because they didn't need it in their particular case. Their charter said that in the event the company's wound up, all the money has to go back to the Hospital for Sick Children, which is the CRA is arguing that's effectively control. But the court said that's not control because they looked and they said out of the 10 directors, there was only 1 common director, and they only had 1 vote. So that's only 10%. That's not controlling votes by any means. And they said, furthermore, when you look at the charter, yes, any money if the company's wound up has to go back to the Hospital for Sick Children, but in the meantime, there's nothing the Hospital for Sick Children can do to force that or control it. This company could decide it's not going to do that for 1,000 years, and there's nothing the Hospital for Sick Children can do to force that to happen. So that's clearly not control. That's just the end beneficiary of it. So they won. And I'm saying this is kind of one of the landmark decisions on what is or isn't de facto control, because there's no right answer to this. It's kind of like a teeter-totter where they look at a variety of factors and figure whether you control it or not. You always want to put your best foot forward. But I'd say it's something that you want to look at, particularly where there's a shareholder who maybe doesn't have voting control, but seems to have a lot of influence, brings in all the contracts, has large loans, particularly demand loans, which if they call it, could force the company to do what they want to do. And you want to mitigate those. You say, let's renegotiate that loan that if you call it, it's payable in 366 days. So I got a year plus a day, which means I can go find other financing, which decreases the likelihood that that's, I mean, like, you could still get me, but it's going to decrease the likelihood of that being a contributing factor to de facto control. So you can take steps, if you understand how the CRA is going to attack you, to go and mitigate as much of the factors as you can to create some ambiguity. And if there's ambiguity, the judge is probably going to side with the taxpayer. If they think it's very clear that there's de facto control, as in the other case, then you're stuck. So you do not want to create those scenarios if at all possible. This is another one. So if we have a shareholder with less than 50% ownership, they don't control it, unless they're related by blood marriage or adoption to other employees that in aggregate control more than 50%. So again, this is very much like the issue on the wages there of confusing specified employee rules, that the payments to a specified employee, they want his salary and wages to have certain limits. Specified employee has more than 10%, but that doesn't mean that they're non-arm's lengths. Okay? Control creates the non-arm's lengths. And again, you don't want to mix those two up, which happens quite a bit. People mess up the definition of specified employee with the control for association, which is more than 50% typically. All color chemicals is a neat case. So as we talked about, there's enhanced incentives if you're a qualified corporation that meet the income and the size test. You have taxable capital and taxable income of the prior year below certain limits. What happened here was we had two qualified CCPCs that did work, that each are 35% fully refundable claimants, qualified CCPCs, that did work in a partnership. Claimed the refundable credits, and when they went to court, the judge said, sadly, oh, guys, I'm really sorry, but the act is crystal clear. A partnership only gets 20%. It doesn't matter who the partners are. A partnership only gets 20%. He comments, had you done this as a joint venture, where you each claim out, then you would have been your 35% plus the on Terra, 45%. But you didn't. Okay? So, if you got qualified CCPCs, you do not want to work in a partnership, because you're only going to go to 20% non-refundable as opposed to your refundable credits. Again, what's funny here is that in Canada there's a difference between a joint venture and partnership. In the US tax rules, they're considered similar. So I mean, this is kind of a dicey area. It's a little more advanced. How do I just structure a joint venture agreement that's going to stand here? And Canada has an IC about all the things they want to differentiate a joint venture agreement from a partnership agreement. You want to make sure you follow that. Yes?
Maybe this is a silly question, but what happens if you have a joint venture between a CCPC and a public corporation?
Then what happens on a joint venture is great. Each company just really records its own cost as if it was its own cost, which it really is, right? So on a joint venture, it's just a deal with you. I keep all my assets here, and you keep all your assets there, and you use yours and we use ours under the terms of the venture agreement, and we claim all our own costs under the terms of that agreement.
So one will get 35% and the other will get 20%?
That's correct. They would get whatever rates that they're entitled to. Exactly. Okay? It's the fact that when you go from claiming directly to CCPC to a partnership, now you've changed the whole legal structure. Okay? That's correct. So the recommendation here is CCPCs do joint ventures, and there's different things they look at a joint venture. Joint venture usually has a fixed life, where a partnership just goes on. Joint ventures usually, we're going to build this building together, and when it's done, that's it. Then we'll manage it, we're going to do whatever, but it's a fixed life, usually a couple of years or whatever, until it's done. And like I say, there's a whole circular on what distinguishes, in the CRA's view, joint venture from partnership. So you want to read that, and you want to structure your contract. Yes, you want to be very careful at the initial structuring of that partnership/joint venture agreement that you don't even call it a partnership. You don't use that term anywhere. There's all kinds of rules that they want you to follow to make sure you don't run afoul. And getting close to wrapping it up now. This is a brand new case from 2012, and there was just another recent one. So here we go. Remember, we're saying that if you have, we'll go back to our case of Mimetex. So 50-50, we're thinking it's still a CCPC, but as soon as the foreign owner would go over 50%, It's clearly voting control. It's foreign control. Well, Price Waterhouse here for one of his clients, Bagtech. And this happened before, and the rules are kind of in a state of flux here. But there was another recent case, similar conclusion here. What they did is they had a majority, about 60% of the shares owned by foreign parties. So you think, well, clearly, voting de jure controlled by foreign parties, foreign can not a CCPC. But they put in a unanimous, what they call USA, a unanimous shareholders agreement in there that says, despite that you guys have 60%, the majority of the directors who control everything, more than 50% of the votes, go to the Canadian directors. And as a result, even though they don't have the ownership, they have the voting control to make it a CCPC. And this has been done in a case called Perfect Fry. It's been done in Bagtech and another one. Normally, what I would say is I believe the Income Tax Act Section 256, because I researched this pretty close. I had a couple clients in similar scenarios that tried to argue this. Parliament changed the law in Section 256 about 3 years ago to prevent exactly this scenario, maybe 4 or 5 years ago now. And I think the judge actually just missed that. I think the judge made a mistake in this ruling that if they read that, which is kind of what we concluded, and when I did it for my client, it held the claim up for 2 years because I had to go to Ottawa, I had to go to finance because they don't want to contradict the tax court judge, but they came back with what I told the client was probably going to happen, which is, I believe this case is wrong. Section 256, if you really read it, would squash this, but I think the judge made a mistake. Nonetheless, is it fraudulent if I say, hey, the judge did it, this is direction, I'm going to follow it? Probably not. It's an application of judgment. So there's no right or wrong on this. I'd say be careful using a unanimous shareholder agreement to create CCPC status, but the aggressive companies are going to do that, and like I say, it seems to be a gray area right now. Sometimes they win, and other times they're losing, so no right or wrong. This is an interesting one. So the client had non-refundable and refundable ITCs, and the government tried to make them use the refundable ITCs against their taxes payable instead of the non-refundables. Seemed kind of crazy to me. I've never seen that. And the court said, no, the taxpayer has the right to order however they want. They can use the non-refundables against tax and get all their refundables refunded. So again, some of the crazy issues, certain CRA review, like when I read this, I thought I would be so offended if the CRA review even hinted that. It seems crystal clear to me. But like I said, the act was crystal clear here. It says the taxpayer may deduct. And when the judge read that, like I say, they focus on the wording of the act very seriously and literally. It said may deduct wasn't a mistake by our elected officials. When they said may deduct, it meant may. It doesn't mean have to deduct. If you have to, it would say you must deduct. But when it says may deduct, that's different than must deduct. End of story. All right, not so much a financial case. It's not a tax court case anymore. It's actually a criminal case in Alberta. What happened here was we had a client, Global Enviro, who had a technologically eligible claim. The science was all good, approved by the RTA, but when they did the financial reviewer said, oops, we've got a problem here. Some of the costs you claimed here in this year appear to have been the prior year. The invoices aren't matching up or whatever, and you're past the 18-month deadline. Had you claimed in the right year, you would have been okay, but you kind of missed the cutoff here. So the client, rather than folding in, from what I can tell from the facts, took the offending invoices in question, changed the dates on them, and resubmitted them to the CRA to make them fit within the year in question. Now, CRA and court said that's called fraud. That's very illegal. Not only is it illegal that you're going to get fined, but it's a criminal felony. So this guy got convicted criminally. He's got a criminal record. He can't cross the border anymore. He can't travel. And this was an appeal. So the Act says they can get a penalty between 50 to 200% of the amount that you submitted in a fraudulent manner. And on the $577,000 that he claimed, he got $500,000 in fines, $250 to him and $250 to his company. And he argued that 80% or whatever was too high, it should be reduced to 50. The tax court judge looked at him and said, you're really lucky you weren't in my court. I would have hit you with 200%. Get out. Okay? So he didn't get a reduction there. Point being, if you willfully misrepresent yourself or you doctor documents in a fraudulent manner, it's not that you lose your SR&ED claim. You lose your SR&ED claim, you get charged criminally, and you get a penalty of probably 1 to 200% of whatever you went after. So they're taking this very, very seriously. You can't fraudulently administer documents, as most of us would tend to agree. All right, any other questions or concluding remarks? I'll stick around for a little bit. This whole course is available on our website if anyone wants to download it, if you don't have hard copies. I'll leave my card here if anyone's interested. And if anyone wants to leave a card here, we'll put you on our newsletter list. We write comments on new SR&ED cases and stuff that come out every 3 to 4 months. All right then. On that basis, we'll wrap it up, and you guys have a good trip back. New SR&ED cases and stuff that come out every 3 to 4 months. All right then. On that basis, we'll wrap it up, and you guys have a good trip back.